This is Alan Kato, and I am going to continue with our program with respect to performance management, and specifically go into the aspects of actually terminating the employment relationship. And to remind the listeners in the audience, I am an attorney, the owner and operator of my own practice here in San Francisco, California, advising employers in all aspects of employment law. So one lead-off topic I want to talk about is with respect to the meeting or meetings that you have with respect to communicating to the employee the terms of a performance improvement plan compared to the meeting that you're going to have with an employee if you are required to terminate the relationship. So the difference between the two meetings, and I want to make this very clear because it's somewhat important from a legal as well as a practical perspective, that in the meeting where you talk about the performance improvement plan, it is important to go over the performance improvement plan in some detail and give good explanations to the employee about what is expected of that employee to satisfy the performance improvement plan. And indeed, you want to invite and give the employee an opportunity to comment on that performance improvement plan. Now, let's compare that to the meeting that you're going to have with the employee if you've gone through this whole performance management process and you're at the point that, unfortunately, you have to terminate the relationship. So in this meeting with the employee over the termination, it is best, and this is my recommendation, it ought to be general and provide a brief explanation. In other words, if you receive a question as to why am I being let go, there should be a brief explanation of the reasons. And instead of inviting an employee to comment or ask questions, you don't want to get into a situation, and you should not allow this meeting to turn into a debate or an argument with the employee over whether or not he was a good performer or not and whether this was a valid termination. Again, it should just be a general and brief explanation that we're here to give you notice that we need to terminate the relationship, and let's now talk about what that means for you in terms of talking about benefits and that sort of thing. So in this termination meeting, it is, again, okay to consider the resignation option in general. Now, there may be situations where even if the employee states that, would it be okay if I resign rather than be terminated, that generally may be okay, but it frankly may not be appropriate in certain situations where you have a termination for serious misconduct. For example, let's say that the employee in question has been accused of serious sexual harassment by a subordinate employee, and your investigation of that accusation has corroborated that this individual did engage in the sexual harassment at issue. In that type of a situation, in order to be able to defend the claim possibly that may result from the employee who complained about sexual harassment, it may be better that your records show that this employee was in fact terminated after an investigation confirmed or corroborated that he or she, for that matter, engaged in sexual harassment, rather than showing that the employee voluntarily resigned the employment relationship. So in terms of explaining the reason for the termination, and again, you don't have to necessarily go into this, but you have to at least be ready to respond to the question, which sometimes is fairly inevitable by an employee. Why? Why am I being let go? Then my guidance on that is, again, be brief and truthful, and most importantly, you see on the slide, don't engage in what I refer to as sugarcoating or white lies, because this type of conduct by a manager can come back to haunt the employer in a later. What do I mean by that? Well, I've given, we have a couple of examples here. So we're going to assume, and this is the same for the other examples, is that the true reason for the termination was the employee's poor performance. Now, in the termination meeting, the manager who conducts the termination says, instead of poor performance, that you, the employee, are being laid off, and or that your termination has nothing to do with your performance, which is not true. Now, how does this get the company into trouble? Well, in the litigation that may follow, the employee's attorney is going to prove that the employer lied. Now, how does that happen? Well, by comparing the reason given in that termination meeting, in other words, that this has nothing to do with your performance, you're being laid off. This attorney will refer to that, and in fact, probably put the manager on the stand and have him testify under penalty of perjury that you told the employee that it had nothing to do with your performance, to then contradict the evidence that the employer is going to have to submit in defense of the litigation that the reason for the termination was poor performance. Also, if the employer says to the effect that this was a job elimination, let's say that that's not true. It wasn't really a job elimination because we fully anticipated the need and did in fact replace that position, even though the terminated employee was told that it was job elimination. This is the sort of thing that will enable the employee to show in the litigation context that the employer lied during the termination meeting, and then plant the seed of doubt in the mind of the jury that if the employer lied, then it could also be that the real reason for the termination was the unlawful reason articulated by the employee, that it was because of unlawful discrimination or some other reason. And to kind of explain this a little bit further, let me explain how this works out in actual court cases. So remember, or not remember, but understand that a manager is going to be required to testify in court honestly and under penalty of perjury as to the reason for the employee's termination. So that means that that manager is going to have no choice but to testify that the reason for the employee's termination was the performance reasons. Now, that means the employer would also have been required to produce documents, including emails related to the reason for the termination, which would reveal performance as the actual reason for the termination. Now, the employee's attorney will then use that information and prove that the manager's testimony is so-called false by pointing out that while the manager testified that he terminated this employee for poor performance, and even though that the employee's personnel file is consistent with perhaps an allegation of poor performance, let's say that under cross-examination of the manager, this manager had said and will have to testify truthfully that at the termination at the termination meeting, he told this employee that the reason for the termination was layoff or job elimination and that it had nothing to do with your poor performance, making it look like, did he lie during the meeting, or did he lie when he was on the stand during the litigation? And as you can see, that is just a recipe for a disaster in terms of trying to defend a litigation. This is the second example on this slide. Again, the real reason for the termination was poor performance. And let's say that the manager had been trained appropriately and he told the employee, you're being terminated for poor performance. Now, how does the employer get into trouble in that type of a situation? Let's say that after the termination meeting, the manager gathers his or her department and tells the coworkers of the terminated employee, and maybe even says this to customers and vendors, that the employee resigned or that the termination was a mutual decision. Again, statements that are inconsistent with the truth, which was that the employee was terminated for poor performance. So this type of so-called sugarcoating with respect to what is communicated to coworkers, customers, or vendors must also be avoided. And it's a simple, the simple way to do that is most employees out there understand, and this is the same for customers and vendors, they understand that employers have an obligation to protect the privacy of its former employees and not go into the reasons why someone has separated. So rather than tell them a white lie, it's simply just appropriate to say, you know, I can't get into why John is no longer with the company. I think you could understand that. And if they don't understand, you explain to them, I have an obligation to protect the privacy of this former employee, John. And it's sufficient for you, the employee asking the question, that he is no longer here, and we should go ahead and go forward with business without him being present anymore, or words to that effect. And that should probably satisfy most questions from coworkers as well as customers or vendors. This third example I provide here is, again, same scenario, employee is terminated for poor performance, and in fact, this is what the manager properly tells the employee, you're being let go for poor performance. The problem, and this is consistent with an earlier part of the program where we talked about new laws with respect to the employer's obligation to respond truthfully to the state unemployment insurance agency. Let's, in this example, let's assume that the company doesn't tell the agency that the employee was terminated for poor performance, but instead responds that the employee was laid off. And as I mentioned, this type of response is generally, in most states, made under penalty of perjury. And guess what? The employee wasn't laid off. He was terminated for poor performance. And now the company has engaged in perjury by doing that. And that's obviously, if it's not clear, it is something that should be avoided of committing that type of legal violation. All right, so what's the solution to this type of a scenario? Well, it should be fairly straightforward, but it often is not the case, and that's why manager training is necessary. That managers should be trained to be honest with the employee about the reasons for the termination. And this is often for managers probably one of the most difficult things that they have to ever do, which is to terminate a subordinate employee. And the temptation is there to engage in what I've referred to as sugarcoating or telling white lies to smooth that process, that meeting. And it's just legally dangerous and practically also not a good idea. So also, not only being honest, it should just be concise and straightforward. I also point out here, and I discourage, and you should discourage your managers from unnecessarily discussing the reasons for an employee's termination. And as I explained here, just state you have a need to protect that employee's privacy, and you simply cannot get into the reasons for that employee's departure. And last but not least, I recommend guarding against this type of inaccurate sugarcoating in the pre-termination documentation and communications. And the examples I gave here of steps or things to avoid is avoid having inflated performance appraisals, avoid sugarcoat made with respect to bonuses and pay increases. And I'm talking about communications directly to the employee or other company or department communications announcing these types of things. And the same goes with sugarcoating with respect to other benefit announcements such as equity awards. So let's briefly talk about the obligations that come not just from having appropriately conducted the termination meeting, but also avoiding legal problems that arise out of post-termination communications. And what I mean is it's not uncommon that employees will go out and try to find other employment, and you will then get inquiries from a prospective employer asking about, okay, so-and-so says he used to work for you, and I'd like to know how he was as an employee. What I recommend, and you probably already have this, but it goes without saying then, that have a policy and enforce it, that all these types of prospective employer inquiries must go to human resources for a response. And human resources should then consistently follow that policy and respond that per the company policy, the employer will only confirm the former employee's dates of employment and final position title, and that's it. All right, let's talk a little bit about what I refer to as the timing problem that comes up quite often in terminating an employee. And this is the scenario where the employee, I call it, sees the handwriting on the wall, and for whatever reason, the employee wants and tries to make it difficult for the employer to go forward with the termination. And this happens usually just prior to the termination, or maybe perhaps even in the termination meeting itself, that the employee engages in some form of protected activity. And the example I give here is submitting some kind of a workers' compensation claim, or asserting for the first time that the employee is disabled. So the dilemma here that I've identified is, if you go ahead and terminate the relationship at that point, is it unlawful retaliation to terminate the employee immediately after the protected activity? Well, first of all, as a legal matter, the short amount of time that may have occurred between the protected activity of perhaps asserting a disability followed by an immediate termination is that, yes, this is a legal indicator of possible retaliation. Now, the solution and how to avoid, if not entirely eliminate, that legal risk is to keep detailed documentation of time and dates of when, first of all, the termination decision was made, and also of recording when the so-called protected activity occurred, where the employee discloses to the employer some type of legally protected status or activity. And the last bullet, which is probably the most important, just because an employee on the cusp of termination engages in some form of protected activity, I do not recommend that you automatically postpone the termination when the employee has raised some previously unknown protected status. In fact, I would suggest that on that type of an occasion, delaying the termination may actually make the situation legally worse for the employer, and that generally it may be best to proceed with the termination if the employer can clearly establish that the termination has nothing to do with the protected activity. By way of a example, there is a case called Arteaga versus Brinks, which is an older case decided back in 2008 by a California Court of Appeal, but in my view, one of the best examples of how an employer avoided legal problems in this type of scenario. So Mr. Arteaga was a guard on a Brinks armored truck, and there were 8 instances of cash shortages at ATMs that Mr. Arteaga was involved in servicing, totaling over some $7,600 in missing funds. So naturally, an investigation ensued. Now, during the investigation, and obviously seeing the handwriting on the wall, Mr. Arteaga asserted that he had a disability that was previously unknown on the part of the employer. Now, soon thereafter, the decision was made to terminate Mr. Arteaga for the funds or the cash shortages, and he was terminated as part of, after that decision to terminate had been made. Now, despite the fact that he had asserted that he was disabled, the court dismissed the lawsuit in the employer's favor and held, and this is the important lesson of this, that Mr. Arteaga could not overcome the documentation, the documented evidence that the employer had raised questions about Mr. Arteaga's poor performance, in other words, with respect to the cash shortages. He could not rebut the employer's documented evidence of performance problems before he disclosed his alleged disability, and where the termination was based, according to the employer, on these same performance issues. All right, so with that, we have concluded this program, and we can, I'm available to respond to questions, and you can do so by submitting them by email or telephone calls to me, and I'd be happy to address them. Thank you very much.